Morning, everyone. Just waiting, I think, for a few more people to come in. It's slow there. I guess we'll get started. Good morning, everyone. Welcome to the Q&A and Happy New Year. A few housekeeping instructions, just reminders as we get started. If you are new to us, please try to stay muted. It helps with the background noise. If you want to ask a question, you can unmute yourself or send a message in the chat, and we'll be happy to answer it if we have time at the end. Remember that everything we talk about today is general information. It is not legal advice. And we have been reminding you since last summer that the recording fees are going up January 1st. It's now January 3rd. So the recording fees have gone up by $100. So keep that in mind. One page, I believe, is $303.50 now to record either a lien or any other document, and then $1 per page after that. I think that is all the housekeeping stuff we need to go over. I do have the link for the proposed bill. People have been asking about it to make all communities subject to Kiowa. Chelsea, do you think you could throw that into the chat for everyone? And then we'll just go ahead and get started. Whoops. Our first question today is association insurance required? One of my associations does not want to opt in. Insurance over common elements, directors and officers insurance, fidelity or bonds is required under 6434 and 6490. It may be required under 6432 if the mortgagee requires it. Often your declaration will also have requirements for insurance. And so you've got to make sure you look at your documents and see if insurance is required under your governing documents. The board wouldn't be following the statutory duty of care if they do opt out of insurance. And you got to remember, the entire association is on the hook for claims for attorney fees against the association if the board decides not to insure. And let's say someone walks in your lobby and slips and falls and sues the association. If you don't have insurance, the claims go back to the entire association as a whole. I think we've talked about this before, but we have an association client who lost something like $100,000 to a phishing scam. That's sort of the modern danger of liability. And if you don't have the fidelity bond to cover that, and they didn't, then you're out that $100,000 or whatever the amount is. Ken, any comments on this one?
Well, I guess I'd want to know more about why the association thinks they don't need insurance. Under most of the statutes, the idea is that you have a common interest, something you collectively own, and you're going to have to insure it. So if you've got some unusual circumstance where you don't have any common property, and we do have some HOA clients where there is no commonly owned property, then it may be appropriate not to have property insurance. And I guess in some associations, you could make a decision about whether you're going to purchase fidelity and directors and officers liability insurance. And it is a risk versus cost kind of analysis. And we're okay with people making those kinds of analyses if it's allowed by your documents. It's just that most of the documents have established in advance that you will buy the insurance. The second question is, can you please review the annual audit requirements for communities under the applicable statutes for each type of community? So for condominiums, which are formed before Ukiah, there is an obligation for every association consisting of 50 or more units to have a CPA audit every year. That's true for new act and old act because the new act says it applies to condominiums created before the new act was adopted. And it is not flexible. It requires an audit if you have 50 or more units. If you have fewer than 50 units, then the association can vote to waive the audit requirement, and it requires 60% of the unit owners to waive the audit requirement. It's not 60% of the people at the meeting, it's 60% of the total owners. Okay. Under the HOA Act of 6438 and under Ukiah, instead of the number of units being the threshold, it's the dollar value of your annual budget. If your annual budget is $50,000 or more, you're required to have an audit. And if your budget is 50,000 or less, you're not required to have an audit. If you are an HOA under 6438, even if you have more than $50,000 as your budget, you are allowed to have the association vote to waive the audit requirement. It requires 67% of the votes at a meeting to waive the audit. So you would need to have a quorum at your annual meeting, and 67% of those owners at the meeting would have to agree to waive the audit requirement. So we have a lot of clients who can't get quorums. If you can't get a quorum, there's no way for you to waive the audit requirement. Okay. So the 6490 has a lower threshold for waiving the annual audit if you get a quorum, because you can do it with a vote of a majority of the community, but you still have to have a quorum for the meeting. One of the things that we as attorneys would suggest is that it's valuable to have the audit anyway. We have had clients where there has been fraud perpetrated for an extended period of time, which should have been caught if there had been audits performed. And because there were no audits performed, the fraud by an insider was able to go undetected for a number of years. So there are valid reasons for having audits. They do have a purpose. It's not just wasted money. And if you are a smaller community, you are trying to balance the cost of the audit against the benefit which comes from having the audit, the same as you're trying to balance the cost for insurance. That's all I got. Did I make any mistakes in that, Lisa, or do you have anything to add?
No, I was just going to add that, we're always talking about kind of keeping owners in the loop and what do you have to hide? And I think an audit is one of those things that can make owners happy, right? I mean, as you said, it helps with avoidance of appearance of fraud and actual fraud. But no, nothing else. Next question. If an association contracts with a sole proprietor business and the owner brings another person to work whom the association is not paying, does the association have an obligation to report this, or is there other legal liability? First off, a sole proprietorship is just a kind of a business. One person owns the business. It doesn't say whether or not they have employees. It doesn't say if they employ subcontractors. So whether or not a company is a sole proprietorship shouldn't have an impact on whether there are other people at the job once you've hired someone to do it. Make sure you have a contract. If you have questions about that contract, make sure you're talking to your legal counsel so you know what the terms of the contract are. If it is a licensed business, and you've made a contract with them for work at your association, you shouldn't need to worry about things like employees, taxes, accounting, and all that stuff. But Ken and I were talking before, and the main risk here is potentially workers' compensation. If your contractor is driving around and picking people off the street who aren't their actual, regular employees, you run the risk of being the insurance essentially for workers' comp if that person gets injured on the job. You want workers to be protected because you, as the association, are ultimately potentially the pockets that the L&I comes after if that person gets injured. So you want to make sure that your contractor is providing, a list of employees to workers' comp so that insurance is not coming from, or that money is not coming from your pockets. There's probably a lot of other information here that we don't have, so I'm not sure what else the questioner is asking, but I think that answers. Ken, anything to comment on that?
Yeah, one other risk would be that the employees need to get paid. If a person works on a property under Washington state's laws, if they are not paid by their employer, meaning the contractor, then they can go to the property owner and demand payment for the services that they provided. And in Washington state, even if you paid the contractor, you will be required to pay the wages for that employee. And so this is part of why we strongly recommend that people hire licensed contractors. You can go to the Department of Labor and Industry's website and look up contractors. You can look up how many employees they have and if their workers' compensation accounts are current. You can look up the kinds of work which the company is buying workers' compensation insurance for. We had a 162 or so unit townhouse community that hired a contractor who had 2 employees under the L&I website. And they had not realized that the contractor was simply turning around and subcontracting out all of the work to 3 or 4 other companies. And they could have learned that if they had looked up the number of employees that the workers' compensation report showed, because they would have then been able to figure out that 2 guys could not re-roof 162 townhouses. So it's, part of the research we do recommend strongly is, look up if they are listed with Department of L&I, have a proper registration with the state for their uniform business identifier so that they're paying taxes, because what you don't want is someone to come back after the association for employees' wages or for taxes for unemployment or workers' compensation insurance. The next question is, if RCW 6490, the Uniform Common Interest Ownership Act, becomes the only law applicable to all communities, will we have to rewrite our governing documents? We're under the Condo Act 6434. We've not updated our governing documents since 2000. So I think we've discussed this before, but to cover again, you'll probably need to talk with your individual attorney to make sure that you don't have anything that's a problem. The new law will trump or override any conflicting provisions in your documents. And this is true every time the law is changed or adopted, is that it doesn't matter what yours says if it is in conflict. So under Ukiah, there is a way to remove conflicting provisions from your old declaration without a vote of the owners. It does mean you're going to rewrite part of the document. It is an amendment to the condo declaration, but it can be done just by a vote of the board of directors after you've informed the owners of the change. So if it's something like the number of days of notice required for meetings, which the statute has changed, then you would be able to make that modification to your documents to be consistent with statute and not involve a vote of the owners. If you are given permission to do something under Ukiah, but it's not in your current document, you would still need to use the standard process for amending your documents and getting a vote of the owners. Okay? We do believe that if the legislature does adopt a single uniform act, which I think they always thought they were doing, that they will provide some means of making that possible and efficient for you to fix your governing documents. And in the same way that they provided an easy, simple way to adopt Ukiah, I think that if they mandate Ukiah, they will probably look at trying to clarify how to fix your document so that it's not as confusing. It doesn't mean it won't be confusing. Um, but if there's a conflict between the new statute and your documents, or the statute requires something which your document is silent about, that will just apply. And I know the goal of this is to try and make it less confusing and maybe require fewer attorneys, but I think the actual result may be additional confusion, and it will become more important for you to have an attorney opinion on what the status of your particular documents are. So I don't know, Lisa, if you've got other thoughts.
No, I don't think so. I think that covers it. Let's see, next question. This is going off the insurance question. What if the CC&Rs state property insurance on the condominium, which may but need not include structures, equipment, improvements, etc.? Do they, the association, have to cover the structures if the owners are responsible to maintain the structures? This is probably getting a little bit too in the weeds for us to really advise on a specific scenario, because the documents and the specifics vary so much from community to community. You'll definitely want to talk with your association counsel and with your insurance professional about what kind of coverages you may need. We talked about this a few questions ago. You know, if you don't have the right insurance or you're not complying with statute or with your documents, you could be in for some pain. But the general rule is there's different obligations for maintenance and restoration after loss. So you should still get the insurance, and that you should need to look to your documents to see how the risks are allocated, because from community to community, can be an entirely different situation. So bottom line, general rule, you should get insurance, but definitely talk to your counsel if you have questions about that, and review your documents carefully. Ken, anything to add on that?
Um, yeah, there's just a big difference between maintaining something and replacing it if it's destroyed by a fire or some other event. So most people don't seem to have a problem differentiating for their cars the difference between insurance to fix it if it gets damaged by, a tree falling on it or someone running into it, and maintenance, replacing your brakes, which the owner has to do. And the property in your governing documents is essentially talking about the same things. You've got maintenance of the condominium units, and that is the owner's obligation. It's like replacing the brakes on your car. And you've got the restoration and obligation to buy insurance for casualty events like fires. And yes, we agree that there gets to be some confusion when the problem is a slow water leak and there is no insurance. And yes, you're going to want to get an attorney's opinion on whether or not you can call that maintenance and shift the obligation back to the owner, or whether it is a casualty event. And it starts to depend on a lot of factors, like whether the event occurred within a 14-day period, or, some other terms, because the insurance policies themselves have to try and have different triggers for what is the difference between a covered event like a fire, which occurs in a very short period of time, and a non-covered event like a leak from wind-driven rain, which has occurred over 30 years. So, the next question, is it necessary to include in meeting minutes a list of all individual attendees or just the board members? And so this starts to be a question about how do you define the word attendee? And we don't see any obligation to list the names of owners who come to observe. They are not attendees of the board meeting. They are observers. And there's also no harm in listing who has come from the membership to observe the board meeting. So I guess is it necessary? No, it's not necessary. Is it okay? Sure, it's okay to list who's come to the meetings. And we do think it is appropriate to list the board members who are in attendance so that you do have an accurate count for the board members and having met your quorum obligations. Anything to add to that, Lisa?
No, I think just in general, I think boards want to have a lot of stuff in their minutes, and they don't need to have a lot of stuff. I mean, typically you just need a record, quick record of what happened, motions made, results of those motions. And so I'm assuming that the question is to see if maybe they could shorten things down, but no, I think other than that, I would agree. Uh, Next question. Our annual meeting is mid-March 2024. New board members will be elected. We meet via Zoom. Can a homeowner nominate themselves to run for a board position during the meeting and present the proxies they collected? Is this valid? Um, First, I would say that if the question is there a difference between a Zoom meeting or people in the same room? No, they're the same. So a Zoom meeting is an in-person meeting as far as whether nominations from the floor work. Generally, nominations can be made from the floor, and generally, if those nominations are supported by proxies and that those proxies comply with the statutory requirements, they should also be valid. Um, you may have different procedures or processes in your governing documents, so make sure you look at those. And if you Google your statute, the word voting, there should be a section on proxies that you can read and figure out whether or not those proxies are valid. We've talked about those in the past. If you want to look at our YouTube channel, see previous conversations about proxies. But basically, yeah, the short answer is yes, they can make a nomination from the floor. Or generally speaking, you can. And most communities do allow that unless they are specifically prohibited in the governing documents. Did I miss anything there, Ken?
I think you've got it. We have some clients who get very concerned about the fact that, they think some dissident is going around and collecting proxies. And part of the, I'll say, response I give is that if you're worried about it, then you as a board member or, can go out and get proxies as well. It's not something that only the dissident owners are allowed to do. So we have some very proactive boards who will go out and collect proxies in advance and can then feel confident that they're going to get a fair representation at the meeting. The only other thing I would say is that proxies do have to comply with the statute. All the statutes match exactly now in terms of how proxies can be presented. Proxies do not need to be prepared by the association. The association does not have to provide proxy forms to the owners because that's not a requirement. If you're voting by absentee ballot, which is different than a proxy, absentee ballots do have to be provided by the association. And it says that in the statute, but proxies do not. And proxies need to be presented at the beginning of the meeting. What you don't want to allow is owners to hold proxies and half an hour into the meeting while you're voting, if the vote doesn't go the way someone wants, they suddenly produce another 5 or dozen proxies trying to change the vote. So proxies should be presented at the beginning of the meeting to the secretary or whoever's presiding over the meeting to make sure that you have a quorum, because proxies count towards a quorum, and to make sure that when you go to vote, you are collecting the votes from everyone who is showing they are in attendance. Next question. An association collects a number of electronic opt-in forms from its owners. These would be via email, signed forms, or other tangible mediums. Can the opt-ins go stale, or are they indefinite, provided the owner doesn't later send an opt-out notice or doesn't receive 2 bounce backs? If the association changes management companies, do the opt-in documents transfer to the new management company, or do they need to get new ones? So the first question is that they do not go stale. There's nothing in the statute which says you have to renew an electronic notice authorization. So they may go stale as a matter of practice because you know they're not being received or you've gotten two bounce backs. But otherwise, they don't go stale. And they are a record of the association. So as long as you have a copy of the original notice by the owner opting in that transfers to the new management company, whether it's because you've got it in a tangible form or you've transferred the email which authorized electronic notice, if those go to the new management company, then those are still valid and can be relied on. We would generally recommend that if you're using electronic notice for something like a fine, that you send it by mail also because you care about making sure they get actual notice. And people tend to not pay as much attention to some documents. Though I've also had a client where the owner objected to getting a piece of mail because they only reviewed their email, and if it showed up in a paper form, they considered it to be junk mail. But the key thing is just to make sure that you are keeping track of undeliverable notices so that you remove people from the opt-in list as they fail to respond or they you get notice of bounce backs. Anything else, Lisa?
No, I had noted that it might be reasonable to at least remind your owners that, that they have the ability to opt in or opt out on some kind of a regular basis. And that may prompt someone to provide you with new, email addresses or new opt-in or opt-out language. It's certainly not required, but it might just be easy, especially if you're worried that things weren't transferred between a new management company and the old management company. But it's certainly not required.
Yeah, we do have some clients that have been very successful at getting virtually 100% of their owners to agree to email notice. Usually these have been in condominiums rather than, HOAs. But I've been, really impressed at their ability to do it. And, there's the potential for a significant savings if you've got a large community and you can get a lot of the people to opt in, especially if you are an HOA, even if you only had a percentage, a third uh, opt in, you could save a significant amount of money.
Okay, next question. Can an HOA's declaration and/or rules and regulations govern the use of public streets within the association? For example, parking RVs, abandoned vehicles, or can the rules only reiterate the city's rules regarding public streets? Um, Generally speaking, the association can probably regulate how owners, park on roads, regardless of whether it's a city street or not, but they cannot regulate the use of those roads or streets by non-owners, right? I mean, makes sense. Those non-owners wouldn't have any knowledge of the association's rules or regulations. So you can regulate your owners potentially, but not non-owners. But it all, this all depends on what your governing documents say. Um, do they cover the ability to regulate what happens on the streets? There also may be some agreement between the association in governing documents or in recorded documents that cover, the municipality has granted the association some right to enforce rules on a municipal street. So, that's potentially out there. But generally speaking, you could regulate your own owners, but again, this is one of those questions where you do need to look to your documents and see what situation may be out there. Anything I missed there, Ken?
Um, well, I would have added that if the governing documents, meaning specifically the CC&Rs, the recorded document, gives you the authority to regulate your owner's behavior on the public streets, then you can adopt rules which would also regulate the owner's behavior on the streets. But if your CC&Rs do not give the association authority to regulate the owners on the public streets, you probably can't do it with rules either, even
Right.
for your own owners. Okay? And then the other thing I had come up with one client was that the um, the association wanted to regulate the parking on the street because vehicles have been parked for months on end, and they had not bothered to look at what the city's municipal code was. And the municipal code had a 3-day parking limit. And the CC&Rs did provide that a violation of the local laws was a violation of the CC&Rs. So the association did have the authority to regulate and enforce the city's parking rules. And since it was a 3-day rule, it would have taken care of what the client needed. Next question. If an owner pays their monthly assessments but refuses to pay other charges like move-in fees, late fees, fines, and they have a track record over the last decade of waiting out the 3-year statute of limitations, what can an association do to collect these fees, fines prior to the 3-year statute of limitations running its course? So I guess I would normally defer to Lisa on this. She's going to correct me.
Okay.
But one thing I would say is that some people think that because of the new laws which prohibit foreclosure, specifically foreclosure on amounts owing other than regular dues or owing at least $2,000 of regular dues, that you cannot use the other collections enforcement actions which are provided for in your governing documents. And that's not true. So if you've got other kinds of fees, even if you can't foreclose, you can still bring a personal lawsuit. You can still restrict use of the common areas if that's what's provided for in your governing documents. So you don't have to just sit and do nothing waiting for the statute of limitations to expire. Another thing we would normally do is look at your method of application of funds coming in. If an owner does not specify specifically what they are paying when they send in their monthly payments, then you can probably apply every payment to the oldest assessment to the property, regardless of the kind of assessment that it is. And so this is one of the ways we do get around the statute of limitation at times is that, they've made random payments, even though they didn't pay that one from 6 years ago. If you applied the payments to the oldest debt first, that means only the debts that are within the most recent 3 years are the ones which are still owing. And your governing documents have to provide for that method of allocating expenses. We do know there was an attorney who for a long time was very specifically allocating expenses first to himself as the attorney. And it really screwed up a lot of the ledgers for some of our clients because it meant that you couldn't just apply the payments to the oldest debts first. But there are other collections actions which can be taken. And just because you can't foreclose doesn't mean that you couldn't use some of those other collections activities against a owner who is trying to work the system. But I'll let Lisa add to that.
Well, I was just going to add that putting on my collections attorney hat, please don't let this happen. I mean, you're basically throwing away the right to collect money that's due to the association. You can, depending on what kind of association you are, you may have a 3 or a 6-year statute of limitations, which we've talked about before, but you can still refer the matter to your attorney. They can still record a lien. They can still send a demand letter. And as Ken said, they may be able to do a personal lawsuit. The association may be able to appear in small claims court and get a judgment against the owner. Filing a legal action is the only thing, aside from the application of funds that Ken was talking about, is the only thing that sort of stops that statute of limitations from running. So you really want to make sure you're not losing the right to do that by quote unquote savvy owner who's avoiding paying and waiting out the statute. So I would say if you're at a year even of someone not paying something and the board's just sitting on it, I think it's really time to talk to them about whether or not they should refer this to an attorney, or at least talk to their attorney about options on how to collect those funds that do not involve foreclosure or may not involve foreclosure.
I will add one other thought, Lisa, is that um, there are times we get these old assessments which an owner is objected to, whether it's a fine or a late fee, or frequently it's an assessment for damages to something which the association manager made, or the association made 3 years ago or 4 years ago. And I would say that we have a significant number of those where the owner didn't pay and the owner had a legitimate reason for not paying. And the history of why the cost was assessed and the analysis on whether or not that assessment was appropriate never was made by the association. And it'll show up in our office and we'll look at this, $50 fine from 4 years ago and see a pattern of the owner paying every other payment that's been assessed to them on time. And we'll basically have to advise the client that we can't, with the documentation they provided, support a collections action for that fine. And we've had a number where the assessment for an insurance deductible has been made against a unit where the documentation just doesn't exist to support that we could validly collect that particular assessment. And it would be much better for you to get some legal advice on whether the assessments are valid early on, instead of waiting 3 or 5 years to determine whether or not that assessment was done properly. And it would be, easier to collect sooner. It would also be easier to fix your governing documents if you need to, in order to make those assessments valid. But it is something that I guess I get confused by. Why would someone wait the length of time that they do to even figure out if the assessment is valid or worth trying to collect? And there are times where I've advised clients, look, it's a $50 fine. Maybe they did owe it. You've waited for 2.5 years. Maybe it's better to just write it off because the owner hasn't had any other violations. They have been, behaving the way that you want them to as a community member, paying all their other debts on time. And so even though it's the principle of the thing, you may want to just let it go and move on with your life. So.
Yeah, I was also going to add that the question, we assume that the fines, fee, et cetera, were assessed properly. There, make sure that your notices and things comply with due process requirements, and follow your rules and collection policies if you have them, so that you can collect those things if it gets to that point. Okay, next question. Are timeshare HOAs governed by the same RCWs that govern condo associations? So this question sort of depends on a couple of things. It depends what we're talking about. If we're talking about the creation of timeshares, that's covered under RCW 6436 if timeshare was created since the statute was enacted. If we're talking about other things like non-payment of assessments, governance questions, then yes, we are likely talking about the RCWs that cover those community associations. And you would look to the governing documents of that association to guide you as to whether, what kind of association they are. When Ken and I were talking, he pointed out that some what we call timeshares were created prior to the enaction of the Timeshare Act. So they're technically not a timeshare. They're a fractionally owned community, and they wouldn't be governed at all by 6436. So there may be some investigation that needs to be done prior to determining what statutes you are covered under. But generally speaking, a timeshare would be created under 6436, and the regulation of the creation of those would be handled that way. But there still would be an association based on governing documents that recorded CC&Rs. We have represented several that are covered that way, and we've done foreclosures, for example, against someone's fractional ownership based on their association documents, and then the governing or the statutes that cover community associations. Ken, did you want to add anything to that?
Yeah, I think the timeshare statute came into existence in the early 80s, and
Okay.
we have a number of fractional condo communities where they were created before the timeshare statute. They even call themselves timeshare in their condo declarations, but they're located out on Lake Chelan or out in Ocean Shores, and they are not timeshare. And I'll offer that our office does not do anything with timeshares under the timeshare statute. And the laws for timeshares don't apply. And so we get into these odd battles occasionally with the attorneys who specialize in selling people's timeshares. And, that's not what we're dealing with. The last question we've got today is, what's the notification process and notification period for homeowner association to announce open board positions and request nominations for these open positions? Okay, so this is going to be exclusively controlled by your governing documents because there is no statutory requirement for any of it. And most of the governing documents are silent about giving any kind of advance notice to people other than to state in your normal notice of an annual meeting that there's going to be an election. So that could mean as few as 14 days notice. If you are trying to get people to serve on the board, then you can reach out anytime you want and as early and as often as you want to encourage them to vote. But most of the documents that we've seen are silent. Most of them allow for nominations to be made from the floor, which means that people don't have to have any notice. They just can, be nominated or nominate themselves at the time of the meeting. And if you're looking to try and do something, the short answer is try and be reasonable. So if you think that people need a couple months notice to think about it, then give them a couple months notice. And you can do it in less formal ways, like just sending out with a newsletter or an email blast, even if that may not hit all of the owners, because you will include the fact that there's going to be an election in the official notice that you send out for the meeting. And then, do check your governing documents to make sure there are not some strange requirements. We have seen governing documents which require nominating committees to be formed or require nominating committees to put forth a fixed number of nominees for the vacant board seats. And we encourage all our clients to follow their governing documents or change the governing documents if they don't like the way they're written. Anything else, Lisa?
Nope, nothing to add. Chelsea, do we have any questions in the chat?
Yes, we have one. Can a board access a unit prior to dispatching services in the event of an emergency, such as a break-in or water loss?
Well, I guess I'm a little confused by the question, but when you say access a unit, if we had a water loss, meaning water's flowing out the front door of a condo unit, I think there's no question that the board would have the authority to access the unit to assess the situation before the vendor showed up. If it's something where it's not an emergency, where you don't have a reason to suspect that there is ongoing property damage, then I would be wanting to understand better why the board would want to gain access in advance of the vendor showing up. But it's also going to depend a lot on the circumstances and the particular governing documents. Some governing documents give the boards pretty broad authority to enter units for inspection purposes. And so if you had a legitimate reason to inspect the unit, then the board would have the right for that access. But I could also see those privileges being abused. And so I'd want to know what the circumstances were. So it's a solid, it depends as an answer. Any thoughts, Lisa?
No, I just saw that a follow-up was, I believe they want to go in and assess in an emergency to confirm the needs for repair prior to a vendor coming out. I don't know that changes your answer.
Yeah, if the owner was available to give permission, that's the first thing I would ask. Call the owner and say, something happened. Is it okay to go in and assess the situation? I would hope that most owners would say, yes, I'd like you to do that. So if the owner cannot be contacted, or let's say you had something like a deceased owner and you have no contact for the estate, then, if the unit is vacant, especially, there's a relatively low risk of going in and assessing the circumstances. We do not recommend that people go inside occupied units when someone is home objecting to their entry. That's a strong don't go in if someone is objecting, because we don't want to have one of our board members or management agents go in and get shot because they are perceived to be an intruder. So you're trying to be reasonable in access. The risk is much lower if the unit is vacant, and it's lower if you've got an emergency that makes it justifiable. And we have had clients where they will try and rely more on the fire department to come in and break the door down instead of doing it themselves, because the fire department will make its own determination, and it would be okay for the board to rely on the fire department's determination that it was reasonable to take emergency access. Is
Any
that
other
it,
questions, Chelsea?
Yes, a couple more came in. How hard is it to dissolve an HOA? We're only 2 members in an agreement. Can we change our governing document about that?
So it may depend on the kind of HOA. If you are a condo and you're trying to dissolve and become 2 separate pieces of property, then you probably can't do it. And I'd have to see the documents to look at, because if you dissolve a condo or terminate the condominium, you recreate a single piece of property with 2 dwellings, and they are jointly owned. So you turn it back into an apartment house, essentially. And that's not usually what the people are trying to accomplish. If you are truly a 2-lot HOA, meaning 2 separate legal properties that are compliant with the local zoning, and you've got 100% agreement to change the CC&Rs or eliminate the CC&Rs, you probably can do that. If you have some jointly owned property, it becomes more problematic. So if you had 2 lots, each with a house and a native growth protection area, which you both own jointly, then you probably can't get rid of the HOA, because the HOA is the legal entity which is going to administer the native growth protection area. So is it possible? If you've got 100% agreement amongst the owners, you can do almost anything in modifying the property rights. But if you're trying to take a condominium association and get rid of it, that is really a challenge, because the termination of the condominium creates one single unified property rather than relieving the multiple properties from their obligations.
There was some additional detail. We share a wall like in a duplex.
But that doesn't tell me whether or not the form of the association is a condominium or whether it is a single family lot community, because you can have single family lot communities, which are townhouses with shared party walls. Seattle's got hundreds of them, the zero lot line townhome communities with no homeowners associations, no commonly owned land, just a whole bunch of easements so people can drive over each other's lots to get into uh, their garages off of a shared easement driveway.
All right. The next question, if time permits, what is the best way to add new board members as signers to the HOA bank account?
So the banks are the ones who control this more than anybody else. And usually what we see is the banks requiring all the existing signers to come in and agree to allow new signers. But it's going to vary by bank, and the bank is who you're going to have to talk to. It also may depend if you've got a management company, there may be no board members at all who are signers on the account. On the other hand, the newer statutes appear to require that for the reserve accounts, only board members are signers. And it's really unclear what the legislative intent was. So I guess I would suggest going to your bank first and asking them what they want to do, or how they want to change. But we have seen real challenges for communities, especially if if the full board has changed hands and the old board isn't willing to go in and sign the paperwork with the bank's not going to accept the authority of the new one. And there's actually lawsuits where if two boards are coming in claiming access to the funds, the bank will sue the association to have the court to tell them which person they can give the money to, because the bank's risk is fairly high if they give it to the wrong person.
And can that may be easier if your bank is accustomed to association accounts, right? I mean, they may, depending on what the bank requirements are, they may take board meeting minutes or something, some other kind of transfer that indication that helps them. But the key is talk to your bank.
And that's true. And some of the banks will look exclusively to the Secretary of State's website to see who is registered with the Secretary of State as board members. And if they are not registered with the Secretary of State, then the bank will not accept that they are a board member. Yeah, it's not an easy process. I wish I could make it easier, but I also understand the concerns of the bank trying to make sure that they are not releasing money to an unauthorized person. And we have had, unfortunately, cases where a board member had stolen money from the association's account because he had a signature authority. And it, reminds me again that you should be buying the fidelity insurance, which is required for many associations to protect the assets of the association.
Anything else, Chelsea?
Lynn?
Some further clarification on the question about dissolving. We are considered a two condo unit. Can we rewrite our laws and change our insurance requirements to individual insurance?
Right. So any condominium association that's under the new act or under Ukiah, I believe, has the ability to remove the insurance for the unit, not for common elements, but for the unit, from being an association responsibility. If you have 100% agreement amongst the condominium unit owners, you can redefine the boundaries of the unit in order to include the entire structure inside of the unit boundaries. You know, that's what we might have called an airspace condo. And we have a lot of airspace condos in the state where the entire structure is inside of the unit boundary. And then we have different requirements for some communities about how that structure is maintained, because the maintenance may be different for the roof than it is for other parts of the structure. And you can change how the insurance is done for the condominiums, but only related to the unit. So if you don't clarify that the building's structure are part of the unit, then you can't eliminate the insurance requirement for the common element in that situation. But we're starting to get really specific in giving advice on that. So did anything else come in, Chelsea?
Nope, that's it.
Okay. Well, then I think we'll be done for today. Thank you everyone for listening, and we'll see you all next week. Thank you.
Bye.